Welcome. My name is Barb Van Hoy. I am a policy analyst with the City of Colorado Springs Community Development Division. Put my face up there. It's always nice to see someone. Even though we are virtual, we try to connect as much as possible. So as I said, welcome to Renter Rights 101. This one is our fourth and final event of this year. And we're just really pleased to be able to produce these events in partnership with Colorado Legal Services, the Pikes Peak Library District, the Justice Center, and Colorado Housing Connects. We will hear from all of them shortly with lots of legal resources and information. But before we dive into the program, I did want to share just a little bit about the digital format, just to help everyone be able to navigate around with the teams live. So as you can see here, everyone is muted. So if you're joining on the computer, you're hearing us just a few seconds delayed. And then for those of you who are on the phone, you won't have access to the typing in question and answer, but you will be able to unmute yourself to ask questions. And so for those of you who are online, you have options to select captions in different languages. So you can see the instructions on screen, how that you first select the subtitles and then select your language of choice. And then you can also click around the question and answers to send us some questions. So we wanted to let everyone know that this event is being recorded, and we will post the video online probably within about a week. We also will share with you the presentation slides, but in order to do that, we need to have your email address. So if you haven't already, you can either sign up for the event registration at the Justice Center's website. We'll post those links in a minute. You can also find these, they'll be posted to the city's Renter Rights webpage at Community Development. We'll post that as well. Or you can sign up if you're not already a subscriber to the Community Development Division's email newsletter. So watch the chat here in a minute, or you can find that at coloradosprings.gov/community development. Also, I want to make sure that you're aware that we do have a Colorado Legal Services Renter Rights Guide PDF that's posted on the website. However, as our attorney presenter tonight will talk about, there are some new laws that have been passed this year around tenant landlord regulations and laws this year, and we're still working on updating that guide. So we will definitely post there when that's updated. So as I mentioned, attendees are muted. Please use the closed captions. You'll also be able to select different captions on the recording once it's posted. Okay, so I think that is almost all of the pre-announcements. The last thing before we get started is we would love to know who is here. So if you wouldn't mind, use the Q&A box to tell us if you are a renter or a landlord or an advocate, or if you're with an organization. We'd love to just learn who's here, who's benefiting from it, why you're interested, so you can share that. We'd appreciate it if you would share that. So the City of Colorado Springs Community Development Division sponsors these events because we are charged with preserving affordable housing, preventing homelessness, and improving struggling neighborhoods. In our role managing the city's HUD grants, we are also tasked with furthering fair housing. So we definitely see that providing practical resources for renters like this event helps to achieve these goals. Ensuring that renters and landlords know their rights and responsibilities helps to prevent unjust evictions and to keep people housed. So I am pleased now to start introducing our presenters. So first, we are going to hear from Deb Hamilton. Deb is the Strategic Services Librarian for who oversees the law and the legal resources collection for the Pikes Peak Library District. And I will let Deb share her screen as well. Deb, do you need me to approve a request?
I can replace your screens. I'm going to go ahead and do that.
Okay.
Okay, can you see my website up to there?
Yep. Okay, now I've got you and your website. Okay, thanks everyone bearing with the technology. So Deb, go ahead and take it away to talk about the resources at the library.
Okay, thanks, Barb. Hi, everyone. My name is Deb Hamilton. I'm the law librarian for Pikes Peak Library District. I just want to show you a few things really quickly on our website that you can easily access from home that would give you more information about some of the stuff that you'll learn about tonight. You can also go to our downtown location where we do have a physical legal research collection. So if you're a person that enjoys looking at things in print and in books, we do have those available at the Penrose Library downtown at 20 North Cascade. But on our website, if you go along the top here, you see a bunch of blue words. Second one in is research. So I'm going to click on that, and I'm just on the main library website, ppld.org. Then after you click on research, this box appears. In the middle here, we're going to click on law collection. You'll find a variety of different things covered on these law pages, but I want to highlight a few things in particular. Mainly if you scroll down, you'll see a guide specifically about eviction information and resources. There you'll find information about where to find landlord-tenant laws. You'll find information about Colorado Housing Connects, which we're going to hear from tonight. You will also find information about the various rental assistance programs that are available, as well as legal information pertaining to evictions. If you ever need help finding any of these things later, you can see here I am over here. So if you click on that, it'll send me an email, or you're welcome to give me a call on my phone as well. Then I'm just going to scroll down a little bit more. Under featured sources, I have a few things highlighted as well that you're going to hear more about tonight. So in just a second, Brit from the Justice Center is going to talk about their services. They do a weekly clinic, and so information about that's right there at the top. Colorado Legal Services, our main presenter, Clinton, he works there. So there's their telephone number and how to get onto their website. When Clinton is giving his presentation, he's going to talk a lot about the Colorado revised statutes, so the laws of Colorado that pertain to the landlord-tenant relationship, as well as how evictions work in the court. You can access those for free online here. And then also the Colorado Judicial Branch, their website, if you go in here and go under self-help and forms, there if you go into housing cases, you'll find forms for both starting as well as responding to an eviction. They also have a section on if you think you're being unlawfully evicted, what to do. And so that website, they really have included a lot of great helpful directions to kind of walk you through the process and explain what the forms do. Last thing I'll just mention too, another free legal clinic opportunity. We run one at the library. We do it on the first Monday of every month. So our next one will be on December 6th from 3:30 to 5 in the afternoon. It is over the phone. So if you want to be placed on the sign-up sheet to get a call from an attorney during that time on Monday, December 6th, you can give me a call here at my phone number or email me and I can get you added to that list. So those are just the things I really quickly want to just show you. I will put some of these library links in the chat so you can easily access them. So thanks everyone for being here tonight.
Thank you so much, Deb. We really appreciate that. Next, I am pleased to introduce Brit Kwan. So Brit is the Executive Director of the Justice Center. And the Justice Center works in the Pikes Peak region to close the gap in access to justice and legal services in the Pikes Peak region. And Britt, would you like me to?
I'm
Oh,
struggling to share my screen. Hold on.
Well, yeah, okay. We're actually seeing your screen, but maybe not the page you're looking for.
Sorry, Barb. Hold
No
on
worries.
just a second. It was just popping up a blank screen. Let's see if this works. Cool. Can you see it now?
There it is.
Okay.
Excellent. Yay, we went over technology again.
Thanks. So the Justice Center, we provide legal aid in the Pikes Peak region. A couple of the things I want to let you know about is we have Call a Lawyer every Wednesday night. This is where you can get free legal advice over the phone. It's always the same time every week from 7 to 9 p.m. Please keep in mind that as the holidays come up, we will be taking a few weeks off, when all of our volunteers will be traveling. So obviously the week of Thanksgiving and Christmas, we will not be able to have this service, but normally other than that, we never miss a week. So you can get free legal advice on Wednesday nights. We do always have folks who can answer questions on landlord-tenant issues. A couple of the other things I'll highlight, you can kind of find everything in our navigation bar on the top of our website. You can apply for a free or reduced cost lawyer. And then a couple of the other things I wanted to share was we have a tenant toolkit that has an eviction prevention toolkit in it, and it's available in English, Spanish, and Korean. So if you want to download this, that is available there. We have some sample housing forms. One of these, Clinton, the presenter, created, and another one is available too. We're hoping to add more to these. So these are just sample forms that you may need throughout your experience as a tenant. The renters' rights workshops are listed here, and then we also have a housing ambassador program. This is for folks who want to be advocates in their spheres of influence for renter rights and help their neighbors or friends understand what their rights are. So if you're interested in that, you can apply to be a housing ambassador with us. And then the last thing I wanted to show you is we have videos on different topics. So we actually have videos specifically on landlord-tenant issues. So if you go to this page, we have a number of different videos. Most of them are available in Spanish as well. So you can just scroll through these and see if any of the topics are relevant to your particular situations. So that is it for me.
Thank you so much, Britt. I am also now going to share the website for Colorado Housing Connects as we bring on Katrina Brown. And Katrina, I think I just need you to show, to turn on your camera. All right. And then thanks everyone as you bear with us. We get all of the technology stuff going. All right. Well, almost. Okay. Here we go. So this is Katrina Brown. So she is a housing counselor with Brothers Redevelopment and can talk about some of the resources available with Colorado Housing Connects. Thanks for being with us, Katrina.
Thank you for having me, Barb. If you will click there on how do I, just kind of hover over there. There you go. All right, this is some of our services that we offer at Colorado Housing Connects. We are a group of housing counselors and housing navigators that work all throughout Colorado. I am in the Colorado Springs, El Paso County office, and we do a lot with renters' rights, and we also do a lot with helping renters navigate through the eviction process and those renters who are in need of funding to keep from being evicted and want to stay housed. We help with that. If you'll click there on I'm facing eviction. So you can go to our website and scroll up just a little bit there and go to the eviction prevention and put in what you're facing, put in your county, and it will navigate you through how to get funding through COVID and through a couple of other sources that are not COVID related so that you can stay housed. Also, if you'll go back up, sorry. I promise I won't have you all over the site. So if you'll go back to how do I? And then from there, we help renters with affordable housing, where we have someone on the line, if you call our Colorado Housing Connects line, to help you find an affordable place to live, to talk to you about tenant landlord issues, and give referrals. We do a lot of referring to Colorado Legal Services and some of the other people that are on the panel. Then we help home buyers as well. We help people who are trying to become first-time home buyers. We have a first-time home buyers class that we teach. We are excited that we're able to teach the class again in person once a month here in Colorado Springs, and we have a Spanish-speaking class in Denver and Thornton that is sponsored by CHAFA, and we also help first-time home buyers get down payment assistance when they are looking to buy a home, whether it be CHAFA or other funding. We have several different ways to navigate you through getting funding for down payments to become a home buyer. We also help homeowners, teach classes to help you stay in your home, because once you get in the home, the goal is to stay there. You've taken on a 30-year mortgage, so you want to stay in your home. So we help to navigate people through preventing foreclosure and doing different things. Just recently, they have released funding for homeowners to get, to stay in their home, just like renters for COVID reasons. So we help navigate through those things. We also help landlords. Especially now with everything that's going on, there are a lot of landlord questions, and there are a lot of things that landlords are needing to navigate through. And we do a whole bunch of other stuff that is not through our Colorado Housing Connects site, that is through Brothers Redevelopment. Feel free to go on our site and just kind of peruse through, and if there's anything we can do to help you, we are always on our line at Colorado Housing Connects.
Thank you so much, Katrina.
No worries.
Really appreciate you being here and showing us about all of those things. And I'll also let folks know that in the Community Development Division's email newsletter this week, we have information about the new homeowner assistance program that opened with the state. So great. Well, those are a lot of incredible resources. Thank you again for all of you being here. And now it's my pleasure to introduce Clinton Albert. Clinton is an attorney with Colorado Legal Services, and he has served there for 3 years. His caseload is made up solely of landlord-tenant matters and covers a broad range of legal issues within this area. We are delighted and honored to have Clinton here. He is going to go through the myriad of issues that tenants and landlords deal with, and what you need to know about the law to help reduce conflicts and manage when those things do come up. Clinton, would you like to share your slides and I can help get them up there? All right. Thanks for being with us, Clinton.
Well, thank you, Barb. Good evening, everybody. My name's Clinton Albert. I'm an attorney with Colorado Legal Services. I want to thank you all for being here this evening. We do have a lot to cover, to include a slew of new law changes that went into effect on October 1st of this year. So I'll just jump right into things. I will try to check the chat periodically just to make sure that I'm not missing any questions. And since I can't really see the chat, if anybody wants to kind of chime in and let me know when questions are starting to flow in, I'll take a pause to try to address some of them. But just some brief little few things to keep in mind. This presentation is for informational purposes only. Housing issues and require a thoughtful analysis of both the facts and the laws that may intertwine in the situation. I apologize, I should have erased this, but You do still see it in some cases, depending on the age of a demand or a notice or an eviction action, and that is prior COVID protection. I will not be discussing those in this presentation. In prior presentations this year, we did address those, and they are also in some prior slide decks as well. If you are a low-income member of the community or a senior and are facing a housing issue, you may contact Colorado Legal Services at 719-471-0380 or in person at 617 South Nevada Avenue. You can also go online at coloradolegalservices.org. So before moving into a new residence, it's an exciting time because starting a new chapter in life, but there are some things to keep in mind as you're transitioning into that new chapter. First of all, as you're applying for a residence, it is important to keep note of the fact that Colorado has banned income discrimination. So what does that mean? Well, it's an unfair housing practice for a landlord to discriminate a person based on their source of income. There are exceptions to that, but as a rule of thumb, source of income means any lawful and verifiable source of money paid directly, indirectly, or on behalf of a person, including income from a lawful profession or occupation, or income or rental payments derived from any governmental or private assistance grant or loan program. And then there's a link to that bill introducing that new law. But one of the main things when you're starting off at a new residence is to keep everything in writing. Put everything in writing and try your best to keep everything in writing throughout the time you're there. A lease is a contract between you and your landlord. Oral leases are valid. However, they're more difficult to prove because it's difficult to really prove, well, this is what the agreement was without it being written down in each party signing on to it. Oral leases are presumed to be month to month. You can't have a lifetime oral lease. So if there's some kind of agreement where you're thinking, well, they told me that I could stay here for the rest of my life, that's not a contract that can be enforced. So make sure that if you're concerned about that, as a landlord or as a tenant, to try to put down the terms of your agreement in writing. That way, everybody's on the same page when you're starting off at your new residence. So before you get to the new residence, a lot of places are requiring applications, if not every place. So Colorado does address rental applications and their fees through the Rental Application Fairness Act. Landlords shall not charge an application fee unless that entire amount is used to cover the cost of processing the application. Cost can be the actual expenses taken on by the landlord in processing the application, or the average expense it incurs when it's processing multiple applicants. So if it's a large-scale apartment complex with lots of different units, then you're likely looking at something where a landlord may be taking an average of the cost that it takes to process an application. Landlords are not able to charge different amounts to different applicants. Landlords also must provide an applicant with a disclosure for with a guesstimate, what the best guess is for the cost, or the actual cost to process an application, and also provide a receipt to the applicant for the fee. Landlords have to make good faith efforts to return remaining amounts to any applicants. So if you are applying, make sure that you provide a good mailing address. In addition to the fees, there's also limitations on what kind of rental or credit history a landlord can consider. For rental or credit history, landlords can only take into consideration the past 7 years. Anything older than that is not a reason to deny an applicant a residence. What about criminal history? Arrest records, those cannot be taken into consideration ever. An arrest record does not indicate that a crime was committed. It indicates that arrest was made. So that cannot ever be used against an applicant. Criminal convictions in some cases can. If it's a conviction within 5 years, it can be used to deny an application. But if it's a conviction older than 5 years, then those have to be pretty limited here. So if a conviction is older than 5 years, a landlord can deny an applicant if that conviction is related, generally speaking, to methamphetamine offenses, not simple possession, but things greater than that. Any kind of offense that would require a person to register as a sex offender pursuant to Colorado statute, homicide-related offenses, and stalking. So those convictions, no matter, regardless of the age of them, they could be held against an applicant. So what happens if you apply for a place and your landlord or the landlord denies your application? Well, if you're a landlord, you have to provide that applicant with a written notice of denial. And as an applicant, that's why, again, it's important to provide that good contact information in the event this does happen. The written notice has to include the reasons for the denial. Landlords, you have to make good faith efforts to provide this to the applicant within 20 calendar days of your decision to deny. So it's not something that can just sit on the back burner and then a few months down the line you say, oh yeah, nope, sorry, decided we were going to deny that application and send it out. You've got to send it out within 3 weeks. So what happens if this law is not followed? Well, as an applicant, you can file a lawsuit and seek 3 times the amount of the application fee that you paid, court costs, and reasonable attorney fees in the matter. However, you must give the landlord notice of your intention to file the action at least 7 days before filing the lawsuit. This gives landlords an opportunity to fix any violations of the Rental Application Fairness Act. If an applicant brings a meritless claim, meaning let's say they bring a claim saying I was denied over a conviction that was 10 years old and it's a murder conviction. Well, that's not a claim with merit. And in that situation, if you're a landlord defending against that, you can seek a judgment for court costs and attorney fees against the denied applicant. And then down here at the bottom, you just have the statutes that address the Rental Application Fairness Act. So we've now gotten past the application stage. We've been approved for the new residents. Now it's time to sign the lease. Leases are getting longer. They can be anywhere from a page to 40+ pages. It is critical that you read each and every page, paragraph, line, sentence, and word of your lease. Review it. Take a magnifying glass to it. Make sure that you are reading everything. This lease is a contract. It's a legally binding document. So you want to make sure that you know what you are signing when you sign it. It is not a defense saying, well, I didn't read the lease because you signed on the lease. So whatever you're signing, that's what you're agreeing to. And when you're reading through it, there's a lot of things that may differ from lease to lease. So it's important to know, what is the length of this lease? Because just because somebody's saying, hey, this is a year-long lease, or you can live here for a year, if that's not what the lease says, then that's not the length of the lease. What happens at the end of the original lease term? Does it roll over automatically? Is it a month-to-month lease? Does it renew for a year? What about potential fees in the lease? Because as we'll get to in a little bit, late fees, if any, have to be disclosed in a lease. What about responsibilities for upkeep and maintenance of the residence? So this is all why it's critical to read through the lease, make sure you understand what your responsibilities are, and also any rules or regulations that may apply to you as a tenant. There's also, take a look to see if your tenancy is an exempt residential agreement. Also warranty of habitability related sections, such as which appliances are included in the lease, and the email address for electronic notice delivery to a landlord. So as indicated on the last slide, some leases may be what's called an exempt residential agreement. This would be a lease for a single family residence or single family home, excuse me. So not an apartment or a condominium. It has to be a property leased by a landlord who owns 5 or fewer single family rental homes. Notice is provided in the lease itself that the 10-day notice period does not apply to the tenancy. I'm kind of jumping ahead a little bit, but the 10-day notice period, that's the amount of time that a tenant would have to fix a lease violation, whether that's non-payment of rent or some other non-monetary aspect, like having a pet or something like that, when the lease says that that's not permitted. No oral leases can be an exempt residential agreement, and that's because there has to be notice provided to the tenant in writing that their tenancy is an exempt residential agreement, and an oral lease, just simply put, cannot have that. So what does this all mean? It gives a tenant 5 days notice instead of 10. So at the end of the day, that's what an exempt residential agreement means, but you want to make sure that you're aware of that by reading through your lease closely. Also, you want to be on the lookout for any kind of lease provisions that are not enforceable under the law. So some of those lease provisions include, as a tenant, you cannot waive or give up your right to the return of the security deposit in the lease. You can't waive your right to the warranty of habitability unless there's a separate agreement, which we'll touch on in that once we get to the warranty of habitability. You can't waive your covenant of quiet enjoyment, which is your right to enjoy the residence as a resident. And you can't waive a 5-day demand for exempt residential agreements or a 10-day demand for unpaid rent. You also cannot waive the court process for a forcible entry and detainer action or eviction, because as a tenant, you have a right to the court process. As I led off with, beginning on October 1st of this year, there have been a lot of new law changes that went into effect, which give tenants some additional rights. One of those new laws indicates that these are new lease provisions that cannot be enforced under the law. So a lease cannot include an unreasonable liquidated damages clause that assigns a cost stemming from an eviction notice or action. So it can't have, there can't be a clause in a lease that says if we file an eviction action, then you're going to owe us liquidated damages in a set amount. All right. A lease can also not include a one-way fee shifting clause that awards attorney fees and court costs only to one party. So what this means is if you review your lease and you see some language about attorney fees, if it says something to the effect that only you would be responsible for attorney fees if your landlord wins, but if you win, then your landlord would not be responsible, that's not something that can be upheld in court anymore. All right. So if there is a paragraph in your lease which does permit attorney fees to be awarded, it has to be to whoever wins the case. It can't just be the landlord only. So main thing here, get a copy of your lease. Right? This is an important binding contract that you're signing, so you want to make sure that you have a copy of it for your records. If there's ever a dispute, this way you can see this was the document that we signed or a copy of the document that we signed. Also, the law does require that your landlord provide you with a copy of the lease within 7 days of you signing the lease. And there's the statute for that right there. It's 38-12-801. As a tenant, you also have a right to receipts for rent and security deposit. If you pay in person with a cash or a money order, you have a right to that receipt immediately. If you pay by mailing by cash or money order and request a receipt, then your landlord has 7 days to provide you with a receipt. As a general rule, make sure that what I typically recommend is that always get receipts, keep it all in the same place. So if you start like a little file folder with your lease, every month, just make sure you're adding those receipts to it. That way you have as complete of records as you can make for your own purposes. Here we go. We've got this is another update in the law. And this one is related to rent increases. So as of today, or not today exactly, but in June of this year, this law went into effect, and it limits the ability of landlords to raise the rent on tenants. So landlords are not able to increase rent more than one time in any 12-month period of consecutive occupancy. So what that means is if you're a tenant, if you've been living someplace for 12 months in a row, you cannot have your rent raised more than one time. Now, if you live there for 3 months, move out for a month, move back in, we've lost that period of consecutive occupancy. And so that limitation on only being able to raise the rent one time in that 12-month period, that's regardless of if there's a written lease or an oral lease. That's regardless if it's the tenancies for a year or a week. And again, it's regardless of if it's a fixed term lease, a month-to-month lease, or an indefinite term. Also, landlords may only increase the rent upon 60 days written notice to the tenant. And landlords may not terminate a residential tenancy with no written agreement by serving a notice to quit with the primary purpose of increasing the rent with less than 60 days notice. So that last part there, to summarize it, as a tenant, you have a right to a 60-day notice in writing of a rent increase. And if you're on a 12-month lease period, keep in mind that your rent can't be increased during that period of time, only after the fact. Now, the last part there is that, let's say you're on an oral lease. Landlords are not able to give you a notice to quit saying, hey, you've got to vacate in X amount of time. We're going to raise the rent to so-and-so, which you can agree to, unless you get that 60 days notice. So rent increases require a 60-day notice at a minimum at this point, if you've been living in the residence for 12 consecutive months. Another pretty substantial change has been related to late fees. So beginning October 1st, there are now quite a few new rules related to late fees. I see a typo right here, and I apologize for it. But if your lease permits greater late fees, that's no longer the case, because the law would trump the lease, and the law has now set into effect limits on what kind of late fees a tenant can face. So first of all, landlords are no longer able to charge a tenant or a homeowner a late fee unless a rent payment is late by at least 7 calendar days. Landlords are not able to charge a late fee that exceeds $50 or 5% of the amount of past due rent. Landlords cannot require a tenant to pay a late fee unless the late fee is disclosed in the rental agreement. So again, if this is an oral lease, no late fees. There cannot be late fees in an oral lease because there's not a rental agreement to disclose those late fees into the tenant. Landlords are not able to remove or exclude a tenant from a dwelling or start a court process for removal or eviction or exclusion because the tenant fails to pay a late fee. All right, so late fees are not a basis to evict a tenant any longer. Landlords shall not terminate a tenancy because a tenant fails to pay one or more late fees. So if you fail to pay a late fee, landlords can't give you a notice to quit for failing to pay a late fee. Landlords cannot impose a late fee for late payment or non-payment of any portion of the rent that a rent subsidy provider rather than the tenant or homeowner is responsible for paying. This had been federal law for voucher recipients, but what this means is if a tenant's responsible for, let's say, 10, 20, 30% of the market rate of rent, but some other agency is going to pay the rest of it, well, the landlord can't charge a late fee to the tenant because that other agency failed to make their payment on time. Landlords also cannot require anybody to pay interest on a late fee. Landlords shall not charge a late. I'm going to keep going here with the late fees. Let me check for questions real quick, just to make sure.
We do have a question about the Rental Application Fairness Act.
Perfect. I'm just waiting for that to load up here.
The question is, does that applicant have to find an attorney in the private sector when pursuing a violation of the Rental Application Fairness Act?
Not necessarily. You can always apply for assistance with Colorado Legal Services as well. I cannot promise that we would be able to take on every matter, but attorneys in the public sector would be able to take on, or at least some attorneys at CLS may be able to take on a Rental Application Fairness Act case. So if that is something that you're interested in, you can certainly apply for services with CLS.
This will be a good time to just remind everybody that these slides will be available if you sign up and register and enter in your email, and we can, I know there's a lot of content on here.
Yes, so please enter your email because there's a lot of slides in this one because there have been a lot of law changes in the last about 5 months here. So kind of picking back up on new limitations on late fees, landlords are not able to charge a late fee unless the landlord provided the tenant or homeowner written notice of the late fee within 180 days after the date upon which the rent payment was due. So in addition to the late fee having to be disclosed in the rental agreement, landlords also have to provide a written notice of the late fee within 6 months of the late payment to be able to charge that late fee. Any lease provision that does not comply with this statute is void and unenforceable. So if you've got a landlord trying to charge late fees that are greater than what's permitted, you can take them to court for injunctive relief. Additionally, a landlord who violates this statute shall pay to the tenant a penalty in the amount of $50 for each violation. A landlord who violates the statute has 7 days to cure the violation, and that time begins when the landlord receives written or electronic notice of the violation. So if you're a landlord trying to charge $100 for $50 of late rent, and you get a notice saying you need to correct this. Think long and hard about correcting that, because otherwise you may be staring down a lawsuit and you may not have a defense to it. So if a landlord violates this statute and fails to timely cure the violation, a tenant may bring a civil action, a lawsuit, seeking one or more of the following remedies down here. Compensatory damages for injury or loss suffered, penalties of $50 to $1,000 for each violation payable to the tenant homeowner, costs to include attorney fees to the prevailing party, and any other equitable relief the court may find appropriate. In addition, tenant or a homeowner, and the reason that it's tenant/homeowner is this also applies to homeowners who reside in a mobile home park as well. A tenant or homeowner may raise an alleged violation of this statute as an affirmative defense in an eviction proceeding. A late fee is distinct from rent, and a rental agreement may not classify a late fee as rent for the purposes of the law. So late fees are when the rent is late. They must be disclosed in the lease, and changing the name of it does not change the nature of a late fee. So it can't be reclassified as something other than a late fee when that's clearly what it is. So we've gotten through the application, we signed the lease, moving truck is pulling up out front of the new residence. Before we start unloading all of the boxes in, grab your phone, grab a camera, walk around and document everything. Take the pictures. Why are these important? Because they're going to document the condition of your residence at the beginning of your tenancy, which may be important at the end of it. Take pictures of everything, whether or not it's damaged or undamaged. Take pictures of it. This documentation may prove to be crucial down the line for security deposit disputes. Try to do a walkthrough as well. Walkthroughs have not really been occurring over the last year and a half, obviously, but if it is possible, try your best to be able to schedule a walkthrough. Why is that important? It's not required by the law, but that way you and your landlord can identify any pre-existing damage. You enter into this tenancy, into your new home, with the same understanding of the condition of the residence. Be critical but not unreasonable here. You're not being a bother by pointing things out that are damaged or pointing things out that don't work in the residence. You are paying for this residence, right? This is a business relationship, and if the other party to this business relationship is not doing what they said they would, you are not being unreasonable by pointing that out. So this way, there's also just kind of a track record of being able to communicate on these issues. So you want to deal with this sooner rather than later. Again, beneficial for this is a business relationship, and I can't stress that enough. Even if y'all know each other beforehand, once you enter into that landlord-tenant relationship, it's a business relationship. Also, keep in mind for rules and regulations. These are additional conditions of the tenancy. Make sure to read through your lease for any reference also to additional rules and regulations. Because if a lease references it and you don't see it, you may unknowingly agree to rules that you have not read. You may receive a copy with your lease, but if you don't, and your lease says tenant will be required to follow the rules and regulations, get a copy of what those rules and regulations are. All right, so moving it, before I jump into the warranty of habitability, I'll just check the questions. I don't see any new questions, so I'll move into the warranty of habitability. This is the promise that your residence is fit for humans to live in. And there are a list of things that by law must be present in your residence. That list can be found in the packet. We'll go through it here in person. There is a prior, as Barb mentioned at the beginning of our presentation this evening, I am working on updating the booklet that's currently online. The booklet that's currently online is not going to be up to date on a lot of matters. So I would not follow that book as strong, or that packet as strongly anymore, given the amount of changes to the law this year. So with the warranty of habitability, and tying this back into making sure you read your lease, is the electronic notice. So a work order, in my opinion, is not notice. What does make up electronic notice? It is notice, so something in writing sent by email or electronic portal or management communication system that is going to be available to both the landlord and the tenant. And if you send an electronic notice saying, hey, I have an issue in my residence, it's uninhabitable, you need to fix it, you can only send that electronic notice to either the email address, phone number, or electronic portal that is specified by your landlord in the rental agreement. So that's why you want to make sure that, hey, where does my lease say that I need to send this electronic notice to? Because if your lease says you have to send it to this email address and you're entering it into some kind of portal system, the law may say that's not a complete electronic notice because it was not sent to the address specified in the lease. Just kind of iterating that, repeating that point there, where, you know, if it says send a notice to an email address and a text message is not noticed. What happens when your lease does not say where an electronic notice can be sent? In that case, that's when you can send electronic notice to your landlord in a way the landlord has previously used to communicate with you. So that's a situation where if there's nothing in your lease about where to send an electronic notice, but your landlord's texted you before, then you can use that to send an electronic notice. So again, if your lease is silent, practice will control how you send an electronic notice to your landlord regarding the warranty of habitability. Also, keep in mind that you must retain sufficient proof of delivery of the electronic notice. If you send an email, try to print out a copy of the email. Just try to make sure that you have some proof that it was sent. So what are the conditions subject to the warranty of habitability? You have a right to have sufficient waterproofing and weather protection of your roof, walls, doors, and windows, plumbing and gas that's in good working order, running water, reasonable amounts of hot water, proper fixtures, connection to sewage disposal system, functioning heating facilities in good working order and in compliance with the law, electrical lighting and wiring and equipment in good working order and in compliance with the law. Common areas under control of the landlord are kept reasonably clean. There's an appropriate extermination in response to infestation. There are more specific rules related to bed bugs that we'll touch on as well. And let's jump right into the bed bugs then. As a tenant, there are certain obligations that you have regarding bed bugs. Okay, so if you know or you reasonably suspect that your dwelling unit contains bed bugs, then you have to promptly notify your landlord in writing or via electronic notice of the issue. Landlords, once you get notice of that, you're on the clock. So within 96 hours of getting this notice about the bed bugs, you have to provide your tenant within the first 48 hours notice of your intent to enter the dwelling or the inspector or a pest control agent. And then you also have to obtain an inspection by a qualified inspector. Landlords, you do have the ability to enter the dwelling unit or any contiguous unit or connecting unit for the purposes of inspection for bed bugs. If inspection confirms that there are bed bugs, then as a landlord, then you have to inspect all contiguous units as promptly as is reasonably practical. These things travel, so it makes sense that if one apartment has it, you want to make sure that the surrounding apartments don't. As a landlord, you are responsible for all costs associated with an inspection for and treatment of bed bugs. That is not a cost that you can put on your tenant, and as a tenant, that is not a cost that you have to pay for. That is your landlord's responsibility. Once that inspection gets completed, landlords, you have then 2 business days to provide the tenant with written notice whether or not the unit contained bed bugs. If the inspection said, nope, didn't find anything, great, but you've also got to let your tenant know that if their concerns remain, that they may contact the local health department. If the inspector confirms, however, that there are bed bugs, then that inspector has to provide a report to the landlord within 24 hours. And then not more than 5 business days after the inspection, so within a week, landlords, you have to commence reasonable measures to effectively treat the bed bug presence, including retaining pest control services. If you hand your tenant a bottle of Raid and say, go to town, you're not doing your job as a landlord. And tenants, if your landlord hands you a can of Raid and says, okay, unit tested positive for bed bugs, here you go, that's not enough. So as a tenant, you have to cooperate and comply with the inspection and treatment of the residence. So the inspections oftentimes or treatment may require you to place items in tubs or to put clothing into bags or rip up any kind of bottom of an upholstered furniture. You've got to comply with that. And you're responsible for all of those costs associated with preparing the dwelling for inspection and treatment. So kind of the same thing where your landlord has to pay for the inspection and the treatment. You've got to pay for the garbage bags that a pest control service may say you have to put all your clothes in. If they say you've got to do laundry on a hot temperature, you're responsible for those costs as well. But as a tenant, if you knowingly and unreasonably fail to comply with the inspection and treatment requirements, then you may be liable for the cost of that treatment and the treatment of any contiguous dwelling units if the need for additional treatment arises from your refusal to cooperate. Landlords, if you know or reasonably suspect that your rental property has bed bugs, you can't rent it. And also, when discussing a potential residence with a prospective tenant or an applicant, if they ask, you are required to disclose whether, to your knowledge, the unit contained bed bugs within the last 8 months, and or disclose the date the unit was last inspected for and found to be free of bed bugs. So I've kind of touched on liability a little bit, but kind of go through it a little bit more here when we're in this area of the warranty of habitability. Landlords, if you fail to comply with bed bugs, you'll be responsible for a tenant's actual damages. Landlords may apply for injunctive relief against a tenant who refuses to provide reasonable access to the dwelling or fails to comply with reasonable requests for inspection or treatment for bed bugs. Landlords, if you find yourself in that position and you take your tenant to court for injunctive relief, if a court finds that the tenant has unreasonably failed to comply, the court may issue an order including granting the landlord access to the dwelling, granting the landlord the right to inspect and treat the dwelling, and also requiring that the tenant comply with specific inspection and treatment measures, or assessing the costs and damages related to the non-compliance. And that may get a little expensive or a little pricey if that infestation spreads to other units. So jumping back into other conditions subject to the warranty of habitability, landlords are required to provide an adequate amount of outside receptacles for garbage. There's not a set number of this many cans for this many tenants, but one of those things where if you're in a fourplex and there's a single can for all four, that doesn't seem to be an adequate amount of outside receptacles for garbage. Also, you have a right to working floors, stairways, and railings, locks on exterior doors, and security devices on windows that open. Landlords are also, it's also required that compliance with all applicable building, housing, and health codes which materially interferes with your life, health, or safety as a tenant in residence. You have a right to have a residence free from mold. Now, mold has a specific definition here. It's microscopic organisms or fungi that can grow in damp conditions in the interior of a building. So when does a residence then become uninhabitable due to mold? Well, a residence is uninhabitable due to mold when there is mold that's associated with dampness or there is any other condition causing the residential premises to be damp, which, if that's not fixed, would materially interfere with the health or safety of the tenant, excluding the presence of mold that is minor and found on surfaces that can accumulate moisture as part of their proper functioning or intended use. So last part there is kind of if you're finding a little bit of mildew in your shower, that's because that's where water is going to accumulate. If you find mold in your bedroom closet, that's not where it's supposed to accumulate. So it's just a difference between the two. I think the best practices related to bathrooms is just to try to air them out as much as possible and don't trap that moisture in, just because that it may very well develop into mold, but not mold that would be a violation of would be a breach of the warranty of habitability. And then so there are, again, going back to the beginning of the presentation, indicated when reviewing your lease, make sure to pay attention to any appliances that are listed in the lease. And that becomes important because appliances are covered by the warranty of habitability. More specifically, refrigerator, range stove, or oven included within the residence for the use of the tenant pursuant to the rental agreement, or any other agreement between the landlord and the tenant would be subject to the warranty of habitability. And this applies only to the appliances specifically listed in a written agreement or otherwise actually provided by your landlord at the beginning of your tenancy. Things like an air conditioning unit, in my opinion, aren't subject to the warranty of habitability at this time. That may change in the future, but at this point in time, there's not a requirement for air conditioning in rental units in Colorado. If, let's say, as a tenant, your fridge goes out, it's a really fancy fridge, one of those smart ones with like a TV in it or something for some reason, and it breaks. And if you make a warranty of habitability demand to your landlord based upon that, the landlord replaces the appliance, there's a presumption that the replacement appliance is not installed in retaliation so long as it has substantially the same features as the original appliance. So if you lose the fancy smart fridge and your landlord just replaces it with a refrigerator that doesn't have Bluetooth, Siri, whatever, that's fine. It's still a refrigerator. It should still have substantially the same features as the original appliance. Also, as a tenant, you have a right to a residence that does not have any conditions that materially interfere with your life, health, or safety. This is somewhat of a subjective. I look at this as a subjective standard that's based upon a tenant's individual characteristics and individual health. And this type of uninhabitability does significantly alter a landlord's response in a warranty of habitability matter. So we've been talking about all of these conditions that are a breach, but when does a landlord actually breach the warranty of habitability? It's not just because your heat goes out. There are other things that have to occur as well. So a residence is uninhabitable when any of those things we just talked about occur, the list of statutes, or it's in a condition that materially interferes with a tenant's life, health, or safety. But just because a residence is uninhabitable, that does not mean that the landlord has breached the warranty of habitability. Because as a tenant, you have to provide your landlord with a notice of this. So it's that the residence is uninhabitable and that the landlord has received a reasonably complete written or electronic notice of the condition and failed to commence remedial actions by employing reasonable efforts within the required time. So when does the breach occur? We've got an uninhabitable residence. We've got notice provided to the landlord and a failure to act by the landlord. Those three things have to be present for a breach of the warranty of habitability. So what are the timelines? When does your landlord have to start taking action on an issue? There are three different timelines really there are three different timelines by the law. The first one is for conditions materially interfering with life, health, or safety, condition uninhabitable by statute, and mold. When it's a life, health, or safety issue, landlords have 24 hours to commence remedial action. And it's one of the other list of things, the windows, the heat, the water, a landlord has 96 hours, so 4 days, to commence remedial action where the uninhabitability is due to the statutorily described condition. But this 96 hours only applies if the tenant has included permission for the landlord or landlord's authorized agent to enter the premises. So if you just provide your landlord with a demand saying, my heat's out, fix it, the 96 hours doesn't apply unless you've included, and you can come into the residence for the purpose of fixing it. So mold has a more detailed process than the other two. So again, within the 96 hours after receiving the notice, landlords have to install a containment stopping active sources of water to the mold, install a high efficiency particulate air filtration device to reduce exposure to mold. Landlords are then required to maintain that containment until the following actions are executed. So within a reasonable amount of time, landlords must establish appropriate protections for workers and occupants, eliminate or limit moisture sources and dry all materials, decontaminate or remove damaged materials as appropriate, evaluate whether the premises has been successfully remediated, reassemble the premises to control sources of moisture and nutrients to prevent or limit any reoccurrence of mold. So, as a tenant, you have to give your landlord the notice of your uninhabitability. Does your landlord have to respond to that notice? Yes. Yes, they do. Within 24 hours of receiving the notice, landlords are required to respond to a reasonably complete notice. And that response must contain a few things. It has to state what the intention for remedying the condition is going to be, an estimate of when the remediation is going to start and when it's going to finish. Essentially, here's what I'm going to do to fix the problem. Here's when I'm going to start fixing the problem. Here's how long it's going to take to fix the problem. What about a request for an alternate residence? In some situations, yes, landlords, you are required to provide an alternate residence to your tenant. If the residence is uninhabitable based on a condition that materially interferes with the tenant's life, health, or safety, and the tenant makes a request for an alternate residence. If that happens, landlords are required to provide a comparable dwelling unit as selected by the landlord at no expense or cost to the tenant, or a hotel room as selected by the landlord at no expense or cost to the tenant. Landlords are not responsible for any other costs that arise after that relocation period. Tenants are still responsible to pay their rent per the terms of the lease during this time. And again, this alternate residence only applies to uninhabitability based upon a condition which materially interferes with the tenant's life, health, or safety. So what can as a tenant, what can you do if your landlord breaches the warranty of habitability? You can terminate the lease. You can seek injunctive relief in county court or district court. You can defend against an eviction for non-payment of rent. You're going to be required to pay a bond, which we'll talk about with these law updates. There's also other monetary options. You can withhold rent. If you haven't provided the prior notice, though, keep in mind your landlord's not in breach of the warranty of habitability. So if you haven't, as a tenant, if you don't provide that notice of the uninhabitability and then you withhold rent because it's not being fixed, you're risking an eviction case being filed. Keep in mind that as a tenant, you can bring a lawsuit against a landlord for a breach of the warranty of habitability, and that does not have to be an eviction case. That can happen on its own. There's also the ability to deduct the cost of repairs from the rent. This is a very specific process. It doesn't apply to everyone. It doesn't apply to every tenancy. You cannot deduct costs for certain issues. I would strongly recommend seeking legal advice before taking this path. Because if a tenant wrongfully deducts rent, then the landlord can take the tenant to court and could get a money judgment in the amount withheld, and likely part and parcel of that is going to be an eviction for non-payment of rent. If it's a bad faith deduction, meaning it's beyond just making a mistake. This is done intentionally and it's done in bad faith. Then a landlord's entitled to an automatic eviction and a money judgment for 2 times the amount withheld by the tenant. Are there any exceptions to the warranty of habitability? Yes, there are. And this was touched on in the beginning of when we talked about important lease provisions to take note of. But there are certain exceptions where a landlord is not responsible for a condition. But in order for that to apply, there has to be a written agreement that is separate from the lease. So there has to be a second contract entered into. The second contract has to be signed by the landlord and the tenant. And the second contract has to be supported by adequate consideration. Also, the tenant must have the skills to perform the work. So if, let's say you're a journeyman carpenter and you agree to perform maintenance on the floors and stairways, and you have a stairway, stairs that fall apart, that's not a breach of the warranty of habitability, so long as there's that separate written agreement that's supported by adequate consideration for the tenant to take on those roles. Again, if you're unsure about whether or not this applies to you, please seek legal advice. So here are some of the updates. These are the updates to the warranty of habitability that went into effect last month. So a breach of the warranty of habitability is a defense to non-payment of rent, but it's now in an eviction action, but it's also now a defense in a collections action for non-payment of rent. Additionally, if you are a tenant and your landlord is trying to evict you for non-payment of rent, and we're talking about the warranty of habitability, as a tenant, you will have to post a bond to be able to use that defense. And typically the bond is set in the amount of rent that's being demanded. Unless as a tenant you are found to be indigent pursuant to statute, then you will not be required to pay a bond to raise the warranty of habitability as an affirmative defense to non-payment of rent. Indigency for the warranty of habitability purposes does have a specific formula here. So if you are a tenant and you are facing an eviction, and in your answer you include that you didn't pay your rent based upon the warranty of a breach of the warranty of habitability, the court will hold a hearing to determine if you're indigent. And indigency is defined as the net income is 5 times or less the annual rental of the tenant premises after allowing all exemptions available to families occupying dwellings in low rent housing authorized under the United States Housing Act of 1937. In calculating the annual rental of the premises, the court must include the average annual cost of heat, water, electricity, gas, and other necessary services or facilities, or the tenant has a net income that is less than 250% of the federal poverty line, and that calculation does not include a tenant's assets. Additionally, the court shall determine the reduction of a premises rental value in its uninhabitable state to the date of the trial. The court, meaning that the court's required to make a determination on, well, this is, if you haven't had heat for this amount of time, this is what the reduction of that premises rental value would be. The court shall deny possession to the landlord and deem the tenant the prevailing party. The tenant has, if that does happen, then the tenant has to pay the rent that has accrued to the date of trial, taking the reduction of value into consideration. So if, as a tenant, let's say you've withheld rent for 3 months and you have your rent is $1,000 a month, so you're behind $3,000. A court finds that your landlord breached the warranty of habitability and deems you the prevailing party, and finds that your home was, the rental value would have been $500. So rather than owing your landlord $3,000, you would then owe your landlord $1,500. You would have to make that payment to either the court or your landlord within 14 days of the court's judgment. And the court, however, if you don't make that payment, the court shall then award possession to your landlord if you fail to pay the reduced rent ordered by the court within the 14 days. What that means is you could go win an eviction trial, but if you then don't pay the rent that's owed within the 14 days, the court's then going to evict you for not paying your rent, the reduced rent to your landlord. In addition, the court may order the landlord to make repairs and to correct uninhabitable conditions. Previously, the court did not have the ability to order a landlord to make repairs. The court shall order that the monthly rent be limited to the reasonable rental value until the repairs are completed. Sorry, another little typo there, but if a court finds that the uninhabitability makes the rent $500 instead of $1,000, then if the court orders those repairs to be made, the rent's going to be $500 until the repairs are completed. And in this case, courts will keep jurisdiction over a case to make sure that a landlord is complying with the court orders. So coming to the end of this, let me check for any new questions.
Hey, Clinton, I also wanted to just remind the folks who are on the phone that if they have a question, since there's so much that you're going through, maybe we can take just a moment and say if you have a question about any of these topics, you can unmute yourself by pressing *6 if you have a question, and then we'll also ask for questions at the end.
Why don't we take now to pause? If anybody has a question, feel free to unmute yourself, and we'll just take a minute here to answer any questions up to this point.
I do know it may take a little while as there's a significant time lag from the live stream to when folks will hear it.
Ah, gotcha. I'll sit right here for just a second, make sure that message gets relayed.
Yeah, so again, it's *6.
All right, not hearing any kind of questions coming in, I'll move forward here. If you are in the process of unmuting yourself, please feel free to interrupt me and we'll try to address the question. So some other resources to consider are going to be the Colorado Springs Planning and Community Development Services Office, the Department of Health, and also the El Paso County Planning and Community Development Office. Code enforcement, or city code, and the warranty of habitability are two separate things. Code enforcement only has the authority to enforce the minimum housing standards of the city code. They don't enforce the warranty of habitability. Some issues are not included in the city code that are in the warranty of habitability. For example, mold is not in the city code, but it is in the warranty of habitability. And I believe window screens are in the city code, but not in the warranty of habitability. So you can send a warranty of habitability demand and also call code enforcement, but keep in mind, just kind of as a general rule of thumb, warranty of habitability is going to be for court. Code enforcement is for city code. Now, the city code can be enforced in court, but that's more of your local municipal courts and not your county courts. So just something to keep in mind. Code enforcement does not have the authority to enforce the warranty of habitability, but a judge does. Moving from the warranty of habitability into security deposits. When can your landlord keep your security deposit? Because at this stage, we've completed our tenancy, we've moved out, and we're waiting to get that deposit back. In some cases, our landlords are able to keep it. They're able to keep portions of the security deposit for any damage beyond normal wear and tear, for non-payment of rent, abandonment of the residence, non-payment of utilities, repair or cleaning work that was contracted for by the tenant. And going back to abandonment of the residence, this is kind of similar to non-payment of rent as well, just because there is that abandonment. And it does indicate that there would be some kind of time left on the lease where a tenant may be financially responsible for it. A non-payment of work contracted for by a tenant. Those are where a landlord can keep your security deposit. So what is normal wear and tear? It's the usual deterioration which occurs when living in a residence. What is not normal wear and tear? Careless or intentional destruction of property. A hole in the wall is not normal wear and tear. Carpets that are worn down from a traffic pattern, that is the usual deterioration which would occur when living in a residence. So if we're at the security deposit stage, then what should we be doing when we're moving out? Clean the residence. First and foremost, make sure you clean it. Try to do another walkthrough if possible. Take more pictures. Take pictures at the end. That way you can show, that way you have kind of a complete set here of this is what it looked like when I started. This is what it looked like now that we're ending it. Return the keys to your landlord and provide them with a forwarding address. Because while your landlord does not have to find your new address, they have to send it to the last known address that they have. So if you don't provide them with a forwarding address, what will likely happen is your security deposit just may be sent to the home you just moved out of. So to avoid that situation, make sure that you provide a forwarding mailing address to your landlord. How long does your landlord have to return your deposit and or a statement of deductions from your deposit? By law, it's up to 30 days. But in the lease, that amount of time can be extended up to 60 days if it is written into the lease itself. So if your landlord does not mail out your deposit, what do? You send him a demand letter, send it via certified or regular mail. Make sure to keep a copy of the letter for yourself. Here's just a sample of it. You can see one of these letters is saying didn't receive anything from you. The other one is saying we received it, we don't agree with the deductions, and stating the deduction and stating the reasons for the disagreement. These letters are required before any kind of further action can be taken. And as a tenant, you must provide your landlord or former landlord with 7 days to cure any wrongful withholding of a security deposit. Excuse me. Your landlord may only end up refunding part of your deposit, so beware of any kind of restrictive endorsement, which indicates that this resolves any and all disputes related to security deposit accounting. If you send that 7-day letter off to your former landlord and you don't get any kind of response to that, you can initiate a small claims action if the amount is under $7,500. You can also seek treble damages if you file that lawsuit within 1 year and a willful withholding is found by the court. Treble damages is 3 times the amount. So if your former landlord kept a $1,000 security deposit and all of that was wrongful, then you could be looking at receiving a judgment from the court in the amount of $3,000. But the court first has to find that there's a willful withholding of the security deposit. So what does willful withholding mean? Well, the case law from Colorado says that if the landlord deliberately fails to return the security deposit during the additional 7-day period, the retention is logically willful under this section. So moving then from, and just on security deposits, while we're still on this subject, the treble damages apply to a wrongfully withheld amount of the security deposit. So let's say that you had a deposit of $1,000, your former landlord kept all of it, you take them to court, and the court finds, well, $800 of this withholding was fine. You missed a month of rent. This is what it was going. This is what the month of rent was. But the remaining $200 is a wrongful withholding. Then you'd be looking at a potential judgment from the court in the amount of $600. So it's only 3 times the amount that was wrongfully withheld or wrongfully and willfully withheld by your landlord, not just the total amount. Early lease termination is somewhat of a tricky subject. This is, again, another very important reason to review your lease entirely, every page, every paragraph, every line, every sentence, every word, because there may be sections in there that deal with what it would take to terminate a lease before the end of the lease term. When is it permissible? That's, again, the language of the lease is going to be kind of the easiest way to determine that. There are certain sets of circumstances which allow tenants to terminate a lease beyond what the lease says. If there's a breach of the warranty of habitability, tenants are able to terminate a lease early. There's also protections for the victims of domestic violence, domestic abuse, stalking, and or unlawful sexual behavior, where an individual provides proof to the landlord that they are a victim, and they are able to terminate the lease early without any kind of penalty. Military orders can also terminate a lease early. Act of God, fire, lightning strikes, flooding, so long as it was not caused by your negligence. For example, if your residence gets struck by lightning and burns down, your landlord can terminate the lease, as can you. However, if you start cooking on the stove and fall asleep on your couch and it burns your house down, it's different. And you will be, the lease termination is likely going to be the least of your problems. But in that situation, that's not going to be a situation where a tenant can terminate the lease early. In addition to, with the warranty of habitability, there are 2 kind of circumstances where a tenant can terminate a lease early based on the warranty of habitability. The first is if the landlord, if you send the the notice to your landlord and they don't take any action, you're able to terminate the lease, the tenancy with between 10 to 30 days after with more than 10, but less than 30 days after you had sent your landlord the notice about the uninhabitability, right? So that's the first situation where there's one breach, but it's not been corrected. So what about when there's multiple ones? And that's exactly what this slide is addressing, where when there have been multiple warranty of habitability breaches, tenants can terminate the lease so long as it is the same condition of the residence which was uninhabitable. So if in month 1 your heat goes out, but in month 4 you have a broken window, those are still 2 warranty of habitability breaches, but they're not the same condition. So it has to be the same condition. It has to be breached twice within a 6-month period. Also, appliances, not the same thing. So if the condition is, well, my fridge is out again, that's not going to be grounds to terminate a lease early. To be able to do this, if it is the second time, let's say your heat's going out in 6 months, you can simply write a 14-day notice to your landlord in writing stating this is the second time this has occurred. I'll be terminating my tenancy in 14 days. Moving into the Mobile Home Park Act. Before we get into this, let's just take a break. I'll check for questions. If anybody on the phone wants to unmute themselves, please feel free to do so. So the question in the chat is that, is there a time limit for filing a lawsuit or claim on the rental application fairness laws? Yes, there are statute of limitations to it. I would honestly have to look at that to know what it is exactly off the top of my head. So there are time limits. Also keep in mind the Rental Application Fairness Act is a fairly new law. So if we're talking about something that occurred, say 5 years ago, that's probably going to be too far removed. But if you're saying this was 5 months ago, that may still be a claim, right? All right, so I will move into the Mobile Home Park Act because I don't hear anybody, I don't see any other questions in the chat. So for tenants in mobile home parks who own their homes and aren't simply renting their home and the lot space, there are additional rights for those tenants. Those tenants, they have a right to a written lease or rental agreement. They have a right to a termination of tenancy must be for cause, as opposed to a notice to quit, which can be served which can just be given at the end of a lease. But homeowners in a mobile home park can only have their tenancy terminated for cause. A demand for compliance, instead of a 10-day period, it's a 90-day period for a homeowner to cure. Again, also a notice to quit, it's not 21 days or 7 days, it is 90 days to move or sell the home. Security deposits in mobile homes are limited. They're restricted and they cannot be greater than 1 month rent. There cannot be any kind of difference between, let's say, a single wide or double wide, depending on the security deposit. Whatever the monthly rent is, that's the maximum that the security deposit can be. Again, with homeowners in a park, the leases also must have additional information in them as well. Management is required, park management is required to disclose the terms and conditions of a tenancy in writing in a rental agreement to any prospective homeowner. And these must include the day that unpaid rent is considered in default for the purpose of establishing a late fee, the name and mailing address where a manager's decision can be appealed, and all charges to the homeowner other than rent, including late fees. So as indicated a couple slides back, homeowners in a park can only have their tenancy terminated for cause. But what's cause? There are legal rules here. It's not just because I said so. The law provides the cause for termination, and that is where a home is not in compliance with local ordinances and state laws and regulations relating to mobile home and home lots. Improper installation of the home can violate regulations and ordinances. So that's something to be on the lookout for there. Not following the park's written rules and regulations. The park is condemned or the park changes use. If a tenant provides knowing false or misleading statements on an application, if you are a homeowner in a park and it's your conduct, a guest conduct, or a friend's conduct unreasonably endangers the life of a person in the park, you are responsible for that in an eviction sense. It's either your conduct, guest conduct, friend's conduct damages or destroys the property of a person in the park in a willful, wanton, or malicious manner, or the conduct constitutes a felony offense or was the basis for an action that declared the home to be a Class 1 public nuisance. Class 1 public nuisance has a set of legal definitions as well. That is not something that is at park management's discretion. That is set out by the legislature. So if a homeowner can have their tenancy terminated for not following the rules and regulations, well, can a park management change its own rules and regulations? Yes, it can. If you permit them, if you give your permission for a rule change, the rule goes into effect immediately. However, if you don't give your permission for a rule change, then that rule will go into effect with 60 days notice. There's also, as a homeowner in a park, you have an expanded right to privacy. And that's park management has no right to enter a homeowner's home without first obtaining the written consent of the homeowner. They can enter to carry out statutory duties. They can enter in the case of an emergency or when the home has been abandoned. And the written consent may be revoked by the homeowner at any time. There's also unique to mobile home parks is the Dispute Resolution Act, which is a mediation program that the state has developed to address disputes between between park management and homeowners. Any party, management or a homeowner, may file a complaint with the Division of Housing. The division then investigates that complaint. If it's appropriate, they may try to facilitate negotiations between management and the homeowner. If that mediation doesn't work, then the division shall make a written determination of whether there was a violation that occurred. And that determination must state certain things you can see here. The basis for the determination, the violation, actions to cure, the time to fix it, penalties if it's not fixed, and the process for contesting the determination and penalties by means of an administrative hearing. If the determination says there's not a violation, the written determination must include the basis for that decision and the process for contesting it as well. Party found in violation has 7 days to comply with a notice of violation. If the party fails to do what is necessary to come into compliance, the Division of Housing can impose financial penalties for each day that the party fails to comply with the notice of violation. They can issue cease and desist orders to stop an unlawful practice. Can order a party to take actions such as refunding money, filing documents that correct a violation, or taking action to correct a violation. If a party wants to contest the decision, that can be done so by requesting a hearing before an administrative law judge. That judge will then hear testimony and receive evidence to decide whether the division's decision is supported by a preponderance of the evidence. And the judge shall enter an appropriate order within 30 days after the hearing and immediately send copies of the order to all parties. So before we get into evictions, I'll just check the question chat here.
And again, folks who are on the phone can hit *6 to unmute yourself if you'd like to ask a question.
All right, well, not hearing anyone, I'll move into the Forcible Entry and Detainer Act. This is the court process for evictions in Colorado. Landlords are required to use the court process. They cannot resort to self-help evictions. The law lists reasons a landlord can start an eviction action. And like I said, I'm working on getting that packet updated so folks can have the most up-to-date information. The first step in an eviction case is really receiving a notice or demand. So either a notice to quit saying you have this much time to move, or a demand saying you're in violation of the lease, you've got to fix it. There's no specific language or state form required for a notice or demand. It just has to comply with the statutes. For a notice to quit, it must describe the property, the date of termination of the tenancy, must be signed by the landlord, and must be served by statutory deadlines. For example, a month-to-month tenancy requires 21 days notice prior to the end of the month. Now, the next step in an eviction case is being served the summons and complaint. So we've got some new updates, some new law here. In the summons, landlords are required to provide tenants with a list of all available resources with a website link and a phone number for residential tenants to obtain civil, legal aid, and rental assistance. They have to provide a copy of a blank answer form. But also, this is new, and I think this is pretty substantial, is that there's also a form that allows either party to request all documents in either the landlord or the tenant's possession relevant to the current action. So if you have a landlord claiming that all of these documents show these violations, you have the ability to request those documents now and have them prior to the trial. So how can you be served with either the notice to quit, demand for compliance, summons and complaint? Either by personal service, which is where somebody hands it to you personally, or service by posting, which is where and service by posting can only occur after personal service is attempted. So that's when somebody's knocking on the door, nobody answers. At that point, it can be taped in a conspicuous location. It can't be folded up and hid under a doormat. It has to be in a place where a tenant is going to see it when they come back. If the summons and complaint is served by posting, landlords are only able to receive a judgment for possession and not money damages. So that is also then, that does not apply if an answer is then filed. So what's an answer? An answer is going to be your legal defenses in response to the complaint. There are, again, some updates here for us to review. Answers are due by 5 p.m. on the date of the return, no longer at 8:30 a.m. The improper notice defense, meaning I did not receive a notice to quit, I didn't get enough time. It can be raised in either the answer or by filing a motion before the trial. However, a tenant cannot raise the defense of improper notice for the first time at the trial if it was not raised in an answer or a pre-hearing motion. Another change here is that it used to be that trials would be held within 5 days of the return date, but now trials are required to be set by the court 7 to 10 days after an answer is filed. Not the return date, but after an answer is filed. So if you file an answer 7 days before your court date, you may have a trial on that date. So just make sure that you're staying up to date on where your case is. Between the filing of an answer and the trial date, the court shall order that the landlord or tenant provide any documentation relevant to the current action. So it's not just that you can request these documents, but the court is also required to order the parties to provide documentation relevant to the current action. Another very large update is the curing non-payment of rent. So with a demand for compliance, it used to be, on September 30th, 2021, the law was that once that 10-day period expires, landlords are no longer required to accept any kind of payment from a tenant. That's no longer the case. So a landlord who provides a tenant with a proper demand for payment shall, meaning required, landlords are required to accept a payment of the tenant's full payment of all amounts due according to the notice, as well as any rent that would remain due under the rental agreement. And a tenant can do that, and a landlord has to accept that payment until a judge or court enters or issues a judgment for possession. Tenants may pay this amount either to the landlord directly or can pay it into the court. Once the court confirms that the full amount has been timely paid, meaning before the judgment enters, the court is then required to vacate any judgments that have been issued and dismiss the case with prejudice, meaning that it cannot be filed again. Also, another defense to keep in mind related, this again, we're jumping back to the warranty of habitability. If a landlord retaliates against a tenant for making a good faith complaint to a landlord or government agency like code regarding warranty of habitability, or organizing or becoming a member of a tenants association or similar organization, the tenant can assert the breach of the warranty of habitability as a defense to the non-monetary eviction, the notice to quit, the rule violation, whatever it may be. So in an eviction case, make sure to, and I put up here in quotes here, because at least here in El Paso County, eviction returns are virtual, so there's not an actual physical appearance. But you want to make sure that you're either filing an answer or filing a settlement, because if you don't take any action, you're going to automatically lose. It's going to be what's called a default judgment. And what happens if there's either a default judgment or if you go to trial and a court were to rule in favor of your landlord? Well, the court would issue what's called a judgment for possession. That's the legal term for eviction. Then in 48 hours, they'll issue this document called a Writ of Restituting. This is the document that allows the sheriff department to come into your residence, remove you from the residence, and then turn possession back over to your former landlord. This document, this Writ of Restitution, cannot be executed until 10 days after the judgment for possession. It used to be 48 hours, but now it's 10 days. We're still talking about a new law, and this is a new law that provides tenants who have been wrongfully evicted with some more damages and more avenues for a lawsuit. So a tenant who's been unlawfully removed or excluded from a dwelling unit may bring a lawsuit, may bring a civil action. The civil action is to restrain further violations and to recover damages, costs, and reasonable attorney fees. So if a court finds that a landlord violated the law related to unlawful removal, then the tenant must be awarded the actual damages and either 3 times the monthly rent or $5,000, whichever is higher. A court may also order that possession is restored to a tenant who was unlawfully removed or excluded from a dwelling. This is a brand new law. I have not had any experience with this insofar as trying out these new remedies that are available to tenants. So this is new. This is something that went into effect again on October 1st of this year. Fair housing. This is both at the state and federal level, there are Fair Housing Acts. It prohibits discrimination based on race, color, disability, sex, sexual orientation to include transgender status, national origin or ancestry, religion, creed, marital status, and or familial status. There may be new additions to this based upon gender identity and gender expression as protected classes in the future. There are exceptions, like most areas of the law. There are exceptions to the Fair Housing Act. The exceptions are for owner-occupied buildings with 4 units or less, single-family housing that is sold or rented without the use of a broker, or housing operated by organizations and private clubs that limit occupancy to members. One issue that'll come up a lot in the context of the Fair Housing Act is service animals versus emotional support animals. Service animals by law can only be either a dog or a miniature horse. They are trained to do work or perform tasks. These medical devices are protected by the Americans with Disability Act. And I say medical devices because these are not a pet. These are medical devices. In my view, they're no different than a nebulizer or an inhaler or anything else. But emotional support animals are different. They are not covered. Emotional support animals are not protected by the Americans with Disability Act. There are possible fair housing protections if somebody's denied an emotional support animal, and that would run afoul of the Fair Housing Act. So this is a situation where a tenant's going to want to make a reasonable accommodation request. What's a reasonable accommodation? So a reasonable what it is discrimination to refuse to make reasonable accommodations necessary to afford a person with a disability the equal opportunity to use and enjoy the residence. Essentially, it's slightly altering a rule or policy so that everybody gets the same use of their residence. There's no magic language to make the request. Again, similar to a notice or demand, but it must be in writing. It must state what the accommodation is that you are requesting. It can't be vague. If you're requesting a grab bar in the shower, say I need a grab bar in the shower. If it's I need a reserved parking spot in the front, say that specifically. There is a sample letter in the online packet, which again, I'm working to get that the updates published as soon as possible. But this is another kind of just a very kind of sample letter here. I'm a current tenant of the address. I suffer from a disability that requires a reasonable accommodation to allow me and my family an equal opportunity to use and enjoy the residence. Then just kind of cites the Fair Housing Act. And then down here at the bottom, I'm requesting landlord, building, whatever, accommodate my disability by providing the specific request as to what it is that you're seeking so that you can get the full use and enjoyment out of your residence. So that covers my slides for this evening. So at this point, I'd like to open it up for any questions that folks have.
Clinton, we do have another question.
Oh, there's one, sorry.
Mm-hmm. So to read it out for the folks on the phone.
I will. And keep in mind that I'm not able to provide legal advice. So if a question is going to get too fact specific, I am going to say that I can't answer that question. So the question is, what type of violation would the property being overrun by vagrants living, sleeping in the halls, stairwells, laundry room, etc.? It may be a violation of the warranty of habitability if it's related to common areas, and those common areas prevent you from using your residence. It also may be a situation where if there are not sufficient, and it may be an instance where you'd want to contact code enforcement, because whether or not the locks on an exterior door to an apartment building function, I don't know how applicable the warranty of habitability would be to that situation. The lock on your front door, yes, but the front door to an apartment building, probably going to take a little bit more analysis. What type of violation?
I have a question.
Guys, I'll be with you in just a second, sir. I've got a couple more parts of this question here. No, that's quite all right. What type of violation is not with enforcement? I'm not really sure what that question's asking. So if it's code, what type of violation is not with code enforcement? I don't know the city code off the top. I don't know the city code. I don't have that memorized. Calling code enforcement does not, again, your landlord cannot retaliate against you for contacting code enforcement. And then what, so I can't state with absolute certainty what is in the warranty of habitability that is not in code enforcement. Mold is not. That is one that I do know because code enforcement has discussed that with me in the past. But beyond that, it may be beneficial maybe to just reach out to code, or the city code is available online, and that's something that you'd be able to locate on your own. What constitutes a violation of peaceful enjoyment? The covenant of quiet enjoyment means that the residence is being able to be used for its intended purpose as a residence. And so if you lost the roof to your home, that may be the violation of the covenant of quiet enjoyment. If, let's say, something got moved in next door and noxious fumes are just kind of being pumped into your residence all day, that may be a situation. But there's not a set statute on these are the things that violate the covenant of quiet enjoyment. So there was a phone caller who, and I apologize, whoever, yes, I think I saw something in there.
I'm sorry, that was me. I didn't know it was that live. That I entered the discussion kind of late, I guess. But I did have a question because I heard where the law had changed, and I know it's changed several times, I guess, recently, or a couple of times at least. But where the question, I guess, is where the landlord is required to accept rent until the judge enters judgment, all the way up until that point. What happens on a landlord's behalf, like as far as like attorney fees and things like that? Are they able to collect those? I mean, if it goes all the way to where you're in court as a landlord, I mean, do you not get? Can you not request from the court attorney fees?
Well, part of that's going to be depending on how the lease is written. All right.
Yes, I know. Yeah. Okay. So if it's written on the lease that you're requesting it, then it's possible that you will get a judgment for that charge.
It's possible. And one of the tricky things then is that as a landlord, you're no longer able to evict a tenant over the non-payment of fees. All right. Correct. So it may be a case where it just may be the case where you might have to take separate action on a collections type action. But without reviewing the lease, without review, sorry,
a lot of times. I'm sorry.
Without it's okay. So, and this is why I can't answer this question in a vacuum, because here are the things I don't know. I don't know what the demand for payment looks like. I don't know what the summons looks like. I don't know what the answer looks like. I don't know if discovery's been complied with. I don't know if there are any defenses to the non-payment of rent. So it's tough for me.
Court costs, attorney fees, like as far as taking it all the way to court for possession, there is charges. There is, they do charge, attorneys do charge to take it that far. What I'm wondering is,
I'm an attorney.
Yeah. Okay.
What I'm saying is that it's the short answer is maybe. Maybe is the short answer, and I don't mean to be. I hope that doesn't come off wrong, but it's just that there's a lot more that would go into that analysis before I could say yes, attorney fees would be proper in this case. Have I told tenants that in the past? Yes, I have. Have I told them in the past that attorney fees are not appropriate? I've said that as well. But I think that's really going to be more of an individual case-by-case determination. So let's say that.
Oh, sorry. Go ahead.
That's okay. So let's say that you've gotten to that point where you've hired an attorney, you've paid them money, you're going to court, but you forgot to sign your demand for payment. Well, I don't think you have a valid demand for payment, so I don't see why a tenant would have to pay attorney when they're going to win. So I'm not trying to punt on your question by any means. But the short answer really is maybe, because whether it's a yes or a no is going to depend on everything else going on in the case.
Because my concern would be, I guess, that this would happen monthly. So say you constantly accept it all the way up to, or every other month, however, whatever the time frames work out to, that kind of thing. It is an expense to have an attorney. So that would be the only thing that I would see, that it requires some kind of, like, somebody should be looking at that, I guess, and saying, man, this guy has to take this tenant every, 2 months to court. He has attorney fees, and it's not clearly outlined, on exactly what the damages are in that part.
With, I hear what you're saying, sir. It also may be it may be a situation where the attorney fees may not be recoverable in the eviction action, but that does not mean that you waive your right to pursue further collection actions.
So outside of the eviction process, you would have to take.
But what I'm saying is, well, you could always spend more money on an attorney to go chase the attorney fees from past cases. But that's what I'm saying on that point. I can appreciate your concern about it happening every month or so, but that's legally, I suppose that's possible. Because
it is very possible.
It could be very possible. I just can't imagine that being a sustainable course. Just because
it is. A lot of times it is. It's more frequent than you would probably. I'm not going to argue with the line, sir. Not going to argue with it at all.
But as far as your original questions about attorney fees on that situation, it's really going to depend case by case.
Okay, I've got another question for you.
Sure.
So, okay. along the same lines, I guess, that the landlord, okay, so the landlord will post a demand for possession based on non-payment of rent, based on damages to the property, broken windows, etc., kicked in door, whatever. So if a landlord accepts the payments and the judgment goes through, that the judge enters a judgment basically and says that no, they paid their late fees. What about the damages? Can somebody just stay in a property continually damaging it as long as they pay their rent?
Separate theories of eviction. So short answer is separate theories of eviction. The paying cures the non-payment issue.
Right.
But if you're saying there are 8 reasons I'm evicting,
Yes.
and they pay, well, you still have 7 reasons that you're evicting.
Right.
So if previously I would have said, yeah, you probably just walked into a waiver argument. But with the new law change, you're required to accept the rent. So I think if you're in a trial, the rent's been paid, and there's still other issues. Yes. I don't believe you're giving up those other issues, because the law doesn't give you a choice regarding accepting your tenant's rent. So you're not giving up on those other claims because the law requires you to accept the rent late, or accept the rent after the 10-day demand. I
hear you. Okay, so like if even like you said, there's 7 different claims. Even if one of the claims are not, broken window, unregistered vehicle, just one thing, then judgment would go in a different way, possibly. Possibly. It depends. You know what I mean? If there's just anything. So look, if you have 5 reasons saying I'm entitled to a judgment for possession for these 5 reasons, right? And a court says, okay, well, I'm finding these 4 reasons aren't valid. You still have one valid reason. So it's not it's not each kind of allegation is on its own. Do I have the proof for this one, this one, this one, this one, or this one? Right. So you can So you can, let's say you have a case where, or you have an issue where there's non-payment of rent, there's an unauthorized pet, and attacked the neighbor with a knife. Well, you've got a non-payment of rent issue, you've got a violation of lease issue, and you've got a substantial violation issue, right? Now, if the knife attack didn't actually happen, okay? If the rent was actually paid, but there's still an unauthorized pet, you still have that legal theory to proceed upon. Right. Okay. That's what my question was. Okay. Thank you. I really appreciate your time. Also, one last question, and I'll let you go. Where can I get this information? Because like I said, I just entered it late, got off work, fixing a rental. So I just entered the conversation, heard what I can, and I have just so many questions, but where can I get this information? So, so if you provide, if you go to the Justice Center website and enter your email address, the slides will be emailed out to you. I'm also working on getting an updated packet on landlord tenant law approved by my superiors, so that can be republished through the city's website. I really appreciate it. And I'm sorry, the Justice Center? Yes, justicecentercos.org. It's in the chat. The link is in the chat if you have access to the chat. Oh yeah. Okay. Oh yeah, you can start from there, and it'll be a lot easier than jotting it down. Yes. Thank you very much. I appreciate your time. Very helpful. I think I've got time for maybe one more question. If anybody has any more, because we are approaching 8 o'clock.
Again, callers can unmute themselves with *6 if you have a question.
Hi, I do have a question. So it's kind of along the lines of warranty of habitability as well as the quiet enjoyment. So if I wanted to terminate a lease on the basis of quiet enjoyment. Is it kind of the same guidelines as the warranty of habitability, where there's the bond for the amount of rent and all of that good stuff?
Nope.
Okay.
The covenant of quiet enjoyment so the covenant of quiet enjoyment is not something that the legislature created by law. It's something that was created in the courts through the common law, which means there's not when I was saying there's not set rules on it, there's legal theories, but there's not a statute that says, here's what happens. If this happens, then the covenant of quiet enjoyment is breached. It's different. So it's not the same type of legal issue that you're going to face with the warranty of habitability, where there's clearly statutory outlines on this is not allowed. If this happens, do this. Landlord doesn't do this, then you can do this. So terminating it's possible that the issues overlap, but without kind of speaking more on a fact-based level, which I can't get into because I can't get into unless you apply for services. The short answer is they're not the same thing.
Okay.
The long answer requires us to talk about your case individually, which would mean you'd have to apply for services to CLA first.
Okay, perfect. Thank you. I really appreciate your help, and I am so glad that you guys had this tonight. I really appreciate it.
Oh, well, you're quite welcome. I appreciate everybody for taking the time out of their day to attend.
Thank
It's
you.
It's much more fun when I get questions.
Well, I think we kept you busy.
Well, any other questions from anybody?
Doesn't look like we have any more on the chat, but just to remind folks, if you sign up with the Justice Center, that is a way to get the slides. But if you want to refer back to the presentation, this has been recorded, and we will post the recording as soon as our communications team folks can get it up before the end of the week. If you go to coloradosprings.gov / community development, I'll put the link up in the chat, but if you go to the fair housing section, I'll post the link now. That's how you can access the recording, and soon we'll have an updated renter's right packet. Is that correct, Clinton?
Yes, that's correct.
And I can jump in with the direct link to the page with the renter rights information on it. So it's at coloradosprings.gov /renters 101. And that will take you right to the page where we have the previous videos of this event posted, and we'll be posting the new one along with the slides as well. So I'll go ahead and wrap us up. If we get another question before we're done, we can jump in on it. But I just really want to thank Clinton and all of our presenters and our partners, Deb Hamilton with Pikes Peak Library District, Brit Kwan with the Justice Center, Katrina Brown with Brothers Redevelopment, and Colorado Housing Connect. And again, Clinton, for putting all of this, spending your time and putting all this together and presenting all this information. We really appreciate it. I want to thank everyone who has attended. I'm going to also go ahead and put up for those online. I have a final slide with some of the links to share one more time. So I would like to just remind folks that emergency rental assistance is still available for folks who need help with paying their rent if they've had an impact from COVID. And then we have the links for all of the organizations who have resources that we've provided. And lastly, don't forget to sign up for the Colorado or the Community Development Division's email newsletter. We send out information almost weekly about housing and resources. And if you find that you have another question after we've wrapped up, you're welcome to email us directly at communitydeveleopment@coloradosprings.gov. And we'd be happy to respond at that time as well. So not seeing or hearing other questions, I think we'll go ahead and wrap up. Thanks again, everyone, and have a nice evening.